with 350 Wisconsin, which is dedicated to combating climate change. She leads the tar sands team within 350 Wisconsin, which focuses on opposing the expansion of Enbridge's Line 5 oil pipeline in northern Wisconsin. Britnie also serves as a chair for the Wisconsin Poor People's Campaign, a community organization that addresses systematic poverty issues. Her involvement spans advocating for environmental causes and supporting communities facing economic hardships. So thank you so much, you both, for joining us, and the floor is yours. So please take it from here. Thank you.
Britnie, you want to go first? You want me to go first?
You can have at it, Connie.
Okay, thank you. I was delighted when Mary Kay reached out, especially given Mary Kay's background, and asked me to come and chat with you. I have my Starbucks coffee, 5 shots, as any Seattleite should. And I'm happy to talk with you about the Bad River Band's objection and opposition to the Line 5 reroute. There are a lot of moving pieces that make up the Bad River Band's resistance, and it has partners in the nonprofit space, Earth Justice, the Clean Wisconsin, the Midwest Environmental Advocates, all strong partners in its opposition. But I want to give you a little history. So about 40 or 50 years ago, Enbridge was granted rights of way to put Line 5 right directly across the Bad River Reservation. Some of those rights of way were agreed to by the band. Some of them were just granted by the Department of Interior through the BIA. When those rights of way grants expired, the line became a trespass, but nobody did anything about it until about 6 years ago, when the band said, hey, wait a minute, this is a trespass, and sued and prevailed in district court. And the district court ordered Enbridge to remove its trespassing pipeline. And it gave them 3 years. And it's in that process right now, even though it's appealing the rightly granted, based upon hundreds of years of Indian law policy in the United States, the rightly granted decision to call it a trespass and require its removal. They're appealing it, but Enbridge is also going through the permitting process to reroute the pipeline in a U shape across the Bad River watershed, just outside the boundaries of the reservation, in some locations as close as 2 miles, 2 river miles from the Bad River Reservation. And they had to go through what's called a 401 certification process. 401 is the section of the Clean Water Act that says if a federal agency is issuing a permit to dredge and fill wetlands, it has to obtain the certification from the state where the impact is going to happen, the discharges are happening, to certify that those discharges will comply with the state's water quality standards. That's 401A1. The state of Wisconsin issued its certification. It has 231 conditions attached to it. The folks who were commenting during the band's public hearing were saying, oh, look how protective this certification is, but it's actually flipped. It means that Enbridge has to comply with all of those 231 conditions. And if it doesn't comply with just one, then its project will violate Wisconsin's water quality standards. It's not protective at all. It's banana pants. And the thing about 401 is that Wisconsin doesn't have to think about any other jurisdiction's water quality standards. It only looks under its framework at Wisconsin's water quality standards. So it didn't take into consideration the downstream jurisdiction's water quality standards because it's not supposed to. That's not the way that the process works. What happens with the process is EPA receives notice of the proposed project, which it received from Enbridge and the Corps of Engineers, and it decides whether it believes a project may affect the waters of a downstream jurisdiction. So not where the actual disturbance is happening, but downstream in a different jurisdiction with different water quality standards. And it made that determination in December of 2024. And it sent a letter to the band saying, we believe this project may affect your water quality standards. Now it's your job, band, as a state under the Clean Water Act, a downstream state, to determine whether it will affect. That's section 401A2 of the Clean Water Act. So a totally separate process, different jurisdictions, different water quality standards, because the band has its own water quality standards that are recognized and adopted by the EPA that are more protective than Wisconsin's standards, because the band has different uses for its waters and for its resources. And in fact, as tribal witnesses testified in both Ojibwe and English during the public hearing, those uses are based upon treaty rights, treaty protected uses that the tribe has engaged in since time immemorial on its lands and in its waters. So there are designated uses of waters for, gathering reeds, for making baskets, which requires the basket maker to chew on the reed, right? So they're taking in sediment contamination that has been uptook, whatever, the resource has uptaken it. And so it's a different use than somebody who might just be kayaking in a water that has contamination in it. There's also designated uses for fish habitat and for tribal cultural uses, for fishing, for ricing, which has treaty right protection and also cultural significance. So all of these things went into the band's adoption of its water quality standards. So it has both numeric standards, you can't have more than this level of contamination, and it has designated uses. You cannot impact a waterway to prevent the use for, and the list goes on. And there's also an anti-degradation policy, which says you cannot degrade existing water conditions by 10% for a pristine water body or 30% for an already impacted water body. All three of those standards have equal importance under the Clean Water Act and under the band's water quality standards. So EPA notifies the band that it believes the project may affect its water quality standards. The band undertakes a comprehensive review and determines that it will affect its water quality resources and violate its water quality standards when the impacts of the discharge reach reservation boundaries. And it notified EPA of this and the Corps in a letter in February of 2025, and it demanded a hearing on its objection to the issuance of the permit, all as permitted and required under section 401A2. That hearing happened May 12th and 13th, or 13th and 14th in St. Paul, Minnesota at the Corps headquarters. And we presented 2 days of technical testimony, expert witnesses, and fact witnesses talking about treaty uses and designated uses of the water resource. And we told the Corps that it would violate the band's water quality standards and that there were no conditions that could be imposed on the permit over and above Wisconsin's 231 that would prevent that violation. And under the Clean Water Act, section 401A2, if that is the fact, would violate the water quality standards, no conditions can be imposed, then the Corps cannot issue the permit. And that is what we told the Corps. You shall not issue the permit. That is the statutory requirement, regardless of whether or not the Trump administration has designated this, an emergency, energy infrastructure importance, all of the things, the bells and whistles that it attached to it. It doesn't matter. Substantively, the Clean Water Act says, thou shalt not issue. Unfortunately, and sadly not surprising to me, the EPA did not support the ban. The EPA made its determination and changed from its may affect determination to a conclusion that it was going to accept the modeling that was submitted by Enbridge, that no impacts would reach the reservation boundaries. It was too far, it was too attenuated, there weren't connections, so there would be no violations of water quality standards on the reservation. But the EPA is not the expert on the band's water quality standards. That's the whole thing about the Clean Water Act. It's cooperative federalism. So the EPA has the Clean Water Act that it implements, but Congress said that states should have a say in what water quality standards are, and tribes who have satisfied the criteria to be treated like a state should have the ability to enforce. Well, if you can't decide whether something is a violation, then your enforcement power is it just doesn't exist. So you have to be able to enforce, which the Clean Water Act says you can. So you have to decide what a violation is of your water quality standards. So The band rejected the EPA's conclusion, and we are pushing back hard against that. But important for this conversation is there is a public comment period that is open until June 13th. So I am busy summarizing all of the arguments we made during the hearing, plus all of the analysis we've done with our expert witnesses and the testimony we've provided. But it is also open for public comment, and it's hard to get there. So I shared in the chat, ignore the first chat, that was for the regional general permit hearing, which we also did, for the one that says shoot, wrong one, here's the correct public notice and comment link. So if you click on that, it will take you to the, and do I have power to share? I can share this. Yes, I can. All right, so I am sharing screen 3. So if you click on the link, it will take you to a PDF of the public notice. On the last page of that PDF, there is a link for public comment. And when you click on that, it takes you here to all of the public comment periods for every core district across the United States. So not necessarily, the easiest thing to find. So if you go down here on the left, if you scroll down to the St. Paul district and click on that, it gives you the 3 projects that are open for public comment in the St. Paul district. And you will see this energy emergency, Enbridge Energy Limited Partnership, Line 5 Wisconsin segment relocation. That is the place where you can provide public comments. And you have to click on this little icon here in the blue to submit your comments. And you'll get this box to fill in your name and your email and your phone number. And then you can either summarize your comments or you can drag a file. You can pre-write something in a Word document. And then you have to pass their security check to show that you're a human. And then you submit it and your comments are submitted. So not the easiest way to submit public comments, probably intentionally. You have to work really hard to get there. So I am happy to share with you my talking points. I have a document, a Word document that I can share with your organization about providing public comments, and you can pick and choose. I mean, I got a bunch of them, obviously, because I've been rattling them off for a long, long time. And so we would welcome public comment. The thing about the 401A2 process is that it has to be related to water quality standards. It can't be, we're opposed to fossil fuel projects, we should be moving away from that. It can't be, it's a violation of the tribe's treaty rights. It can't be, this is not an energy emergency. It has to be focused on the water quality standards of the band. So it's fairly specialized, which is why I'm happy to provide some talking points for you. The other thing that's happening, I said there's a lot of moving parts, is that Earth Justice on behalf of the band and its nonprofit partners have challenged the 401 certification by the state of Wisconsin. So the state of Wisconsin again certified that this project, if you do these 231 conditions every time you operate it, will not violate water quality standards. The band has challenged that and said that issuance violated Wisconsin law, and Wisconsin failed to go through the process it was required to do. It failed to consider all the things it's required under Wisconsin law to do. So that's a contested case hearing, and that's coming up very, very soon. The Earth Justice has argued that the 401A2 hearing shouldn't have even happened because with the appeal, the contested case, the appeal of the certification suspended its effectiveness. So there isn't even a 401 certification under 401A1 right now because it's suspended pending appeal to the contested case and then an appeal from that. The Corps just rejected that and moved ahead. So that's happening. That will be tried. Of course, you can attend that. I don't know if it's going to be by Zoom or if it's going to be in person, but Earth Justice has been getting the word out for that along with its partners, Midwest Environmental Advocates and Clean Wisconsin. And we would obviously welcome your support for that as well. And that's Wisconsin stuff, outside the reservation, but in the Bad River watershed, all of the impacts from all of the nasty things that they're doing that the band has identified also obviously will impact Wisconsin writ large.
Thank you so much. Thank you so much, Connie. Yeah. Brittany, do you want to chime in?
Before she does that, could I just ask a follow-up question to Connie? I know you've been working with the tribe or the band since what, 2014 or something. It's a lot of years. Did you have something to say or help them with making sure that their standards were well written? Were you involved at that level, perhaps?
I actually, they developed their water quality standards before I started representing them. What I have done is I drafted a Bad River Superfund statute. It's called the Environmental Response and Remediation Code that actually has been imposed on Enbridge when they had the helicopter crash and spilled aviation fuel all over in the wetlands. Bad River Band law applied to the cleanup, not Wisconsin law. And so I have worked to develop that infrastructure for the band to be able to impose cleanups to Bad River standards, which includes Bad River water quality standards, as well as soil standards and sediment standards. And I developed an enforcement manual. We've actually enforced against an off-reservation fee landowner, non-tribal, who was operating a junkyard that threatened downstream ricing areas. And so we had an off-reservation enforcement with a cooperative landowner. We did an investigation and determined that there wasn't a threat and release. But yeah, so I have helped the Natural Resources Department build itself up to the point where it is an enforcement agency for ensuring the protection of the band's natural resources.
Thank you.
Brittany, go ahead.
Yeah, sure. I can talk a little bit more about the contested case. 350 Wisconsin is part of that. We're represented by Midwest Environmental Advocates alongside Sierra Club and League of Women Voters of Wisconsin. So in November of last year, 2024, the DNR issued the permits that Enbridge needs to be able to move forward with the reroute. And I think one really notable thing about that is, like, fast forward a month to December, we find out that they knew a few days before issuing those permits that Enbridge Line 6 had actually spilled in the southeastern part of Wisconsin. It ruptured nearly 70,000 gallons of oil. This was an underground spill that had been going on for quite a long time, apparently. So they knew this and still continued to move forward with issuing those permits. Yeah, so we are represented by MEA. We're taking legal action to block these permits because we know that Enbridge has failed to show that its plans will minimize harm to the water bodies and wetlands that will be impacted by the pipeline construction. They actually have not identified exactly which waterways and crossings will require blasting through bedrock. That's something that they're saying, like, we just kind of have to go in and see what happens to figure out, like, what needs to be done, which is absolutely unacceptable. So they are absolutely understating the environmental damage. I don't know if anybody was able to listen into those hearings, but one thing that really stuck out to me, you know, with the water quality hearing was that they were saying, like, oh, it's not like blasting isn't that big of a deal. It's not like you see in the movies, and, you know, it's like responsible blasting, which is just completely absurd in my opinion. Yeah, so we are a part of this this challenge. And like Connie said, that schedule is going to be starting pretty soon. So I can share a link in the chat. This has more information on it, just about, you know, what we're challenging, why we're challenging it, kind of a little more detail and a few more pieces on that. One great thing that did happen already is that the ALJ, the administrative law judge, Angela Chaput-Foy, did grant our request for a stay on any construction. So technically, Enbridge cannot cannot move forward with any sort of construction while this case is going on. So the first date that's coming up is going to be August 12th in Ashland. That's going to be opening statements and public testimony. I do want to kind of warn everybody that this is not like a regular public comment, public statement situation, because it is the type of case that it is. Anybody who chooses to comment or testify during the public comment session will be subject to cross-examination by all of the attorneys, including Enbridge's attorneys. And you know, we know that they've made people cry in the past. We know these attorneys, we know who they are. So this is a pretty intense process. It's not something that you should just go into without thinking about it. You know, we're never going to tell anybody that they can't participate, but it's a really intense process, you know, to go through to participate in that, just, you know, kind of due to the type of case that it is. And John, I did see your comment. So the deadline has actually passed for anyone else to join in that way, but really appreciate it. Yeah, so August in Ashland, and then in September, there will be another public testimony in Madison. Excuse me. And then that'll kind of continue September to the beginning of October. It's kind of a staggered process here, a little bit out of order just due to people's availability and schedules. But everything that is listed on the MEA website is accurate as far as dates go and locations.
Thank you so much. Thank you so much.
We
for
have a
that.
question. We have a question here for her.
Has anybody ever heard of a pipeline that has not leaked? That should be the primary #1 question for me. I have never heard of a pipeline that hasn't leaked. I know that South American countries and European countries have all banned these pipelines, banned these companies from their countries. And I'm wondering why that isn't a primary question and criteria for approving a pipeline. I don't know of one that hasn't been that hasn't leaked. Eileen Flanagan was up in Minnesota when they were doing the pipeline up there. She saw it leak. She saw them cover it up. And that would seem to be the biggest question that I would want answered, and I would want the judge to respond to. And then when you consider Lake Superior and the force of Lake Superior and putting a pipeline under there, Lake Superior is absolutely furious. It is a force of nature. And I cannot imagine a pipeline standing up to that. They haven't stood up to rivers. How in the hell are they going to stand up to Lake Superior? So I guess my question is, has anybody heard of a pipeline that is not leaked?
I think two things that are kind of coming to mind for me right away are, you know, Line 3 in Minnesota, obviously, you know, that was brand new pipeline. I think there are there's some evidence to show that new pipelines are probably even worse than like old ones as far as the reliability of them. The newer ones tend to leak very often. The other thing is that, you know, it seems like this is logical stuff to us to think through these questions and these processes, but, you know, DNR and EPA self-limit themselves on what they say they're in charge of, you know, what their guidelines are and where their area of expertise is and what they can and cannot chime in on and regulate. So, you know, that's another big thing. It's just they self-limit and tend to, you know, agencies tend to point fingers at one another and say, we're not responsible for that, they are. And, you know, it's just kind of an endless cycle from, from what I've seen.
I can chime in about the pipeline leakings. I think it's important So understanding the opposition is always a key thing for a trial attorney. But so understanding the position that these regulatory agencies are coming from, whose job it is to actually issue permits, right? So that's what DNR's job is, to issue permits to allow things to be developed in Wisconsin. Pipelines leak. I think that's just a universal truth that pipelines leak. The way that agencies who issue permits get around that is, oh, well, do they have a spill response plan? Can they address a leak when it happens? So the leak would be de minimis, unless of course it's happening underground and leaking for months before somebody figures it out. But yes, so the idea is a de minimis leak isn't really a leak. It's not a spill, it's just de minimis and then they'll clean it up. So the fact of the leak gets washed over. And I analogize it to mines. So mines also get permits issued by departments of natural resources for the use of resources in the state, and they require reclamation plans. But a reclamation plan doesn't mean restore it to look as though it never was mined. Reclamation usually means just returning it to its original contours. But there's a concept called a sacrifice zone that is built into these permits, that the place where the mining has actually happened will never, ever, ever look the way it was. It will never, ever, ever look like no mining ever happened. It is sacrificed, and that is built into the permit. So when you're talking to these agencies, that's what's happening at the back of their mind is, oh, well, we've got a sacrifice zone, or, oh, we've got a spill response plan. So that's taken care of. It's not a release. We're not going to worry about environmental contamination because, oh, they'll clean it up. So you'd think the fact that Enbridge is a Canadian corporation would have affected this permit process, but of course, this has been designated one of the permits subject to an energy emergency under the executive order that says you can do away, you can shorten the time frame and you can limit the environmental analysis. Yeah. I think that happened before we went to war with Canada.
Yeah, I mean, I'm just flummoxed by the fact that a foreign corporation has more power in our state than people in our own state. I just find that amazing myself.
Yep.
And the eminent domain stuff, I mean, that just, as a farmer, everybody I know along the pipeline that had their land taken by a foreign corporation.
Yep.
I mean, that's just like blows my mind. I mean, how is that ever a public good? Anyways, and I teach economics, so I have to try to talk about eminent domain to my students all the time, but it's supposed to be for a public good. This is not a public.
Yep. No.
There's also, I think it was the treaty of, what was it, 1972 or something, that they've been trying to, leverage, basically stating that Canadian pipelines can go through anything no matter what. That's really like putting it in super basic terms, but it doesn't matter, and that really overrides everything, which is, that's insane.
Yeah. And Dane County wasn't even allowed to require liability insurance for the Line 61 section through so like they even took away local control over liability insurance for these things. So I don't, yeah, it's frustrating.
I have a question, Shazhad, for Britnie. I'm just wondering, Britnie, those hearings up in Ashland in Madison, where they're going to make people cry, are you still encouraging people to come and listen and be there for the hearings? Should it be something I'm announcing and sending out to our member groups across Wisconsin?
I am not encouraging or discouraging anything.
Okay.
If that's something you would like to share, Judy, you go right ahead.
Yeah. Okay. I'll just watch what 350 puts out and
I don't know where this is going to be posted, but I'm just going to say that as a party in this lawsuit, there are certain things that
right.
would say.
Yeah, it just seems to me like I'd be interested to just go and listen, even though I'm not saying anything, to find out what the arguments are going on and stuff. So I'll look for other places too that are posting that, and because other people might be interested. Thank you. Such good information, you guys, putting all this together. I really appreciate it. Thank you.
And I think this is a good segue to what Connie was mentioning, comments specific to water standards. And you were willing to share some templates or some ideas. So would you mind taking some time sharing some ideas for us when we are making public comments online?
Sure.
And I saw your email, so yeah, thank you so much for sharing. So we will also send out emails with the details, with the links that Connie and Brittany shared with us. So I'll send it to Judy and she can send it to folks.
Okay, I have to try to figure out where I sent my document. I just minimized it on my screen and now I can't find it. So hold on a second. I'm happy to share my talking
That
points.
is fine. Take your time.
A page-and-a-half document that I shared that I'm happy for you guys to draw from. So it may be something that you are more interested, some topic that you're more interested than another. Like, for example, the mercury issues that were raised by Dr. Branfirerun during the hearing. One thing that he pointed out was it's not just the area downriver that is impacted by the blasting and the changes. The fact that the proposed line will run horizontally or perpendicular to the watershed has impacts both upstream and then downstream. And why can I not get this document to come back up? Well, I know where I can find it. I sent it to you, so I will pull it out of there. So it's a wetland rich environment, the Bad River watershed. If you've ever been out there, there's just wetlands forever, and they are hydrologically connected. The old national database information about the connectivity and the volume of wetlands is underestimated. And the Great Lakes Indian, what is GLFWIC? GLFWIC, Great Lakes Indian Fish and Wildlife. Yep. Commission has done lots of mapping work. And so Esteban Chiriboga testified at the hearing, and he testified about how the hydrologic connections are far more significant than EPA relied on. And the numbers of wetlands have like tripled in areas where they've done walking on the ground estimates of it. And he testified that there is, oh, thank you. He testified that there is no doubt in his mind, based upon all of the work that he's done, that this impacts are going to head downstream to the reservation, especially in locations where it's only a mile or 2 river miles upstream. He testified in the Fond du Lac Band's objection to the Polymet mine project, in which EPA agreed with the Fond du Lac Band for a variety of reasons, all of which we've talked about in the Bad River Band's case. But that was like 200 river miles from the mine to the reservation. And EPA had no problem accepting that the contaminants that are released from that project would end up in the reservation. So I'm not quite sure why they think a mile or 2 miles is sufficient distance for the contaminants to settle out, but that's the modeling that that the Enbridge experts provided to the band, or excuse me, provided to the EPA and at the hearing, even though, you know, they testified at the hearing, even though they have absolutely no role under 401A2. They were afforded the opportunity to provide expert testimony. Okay, so if you guys can pull up your talking points that are in the chat, we can walk through, and I have put together the key points that we raised, the band raised during the public hearing. And so a lot of these have also been shared by Midwest environmental advocates, so they'll look aligned. So it just talks about the scope of the project. Here, I can now share my screen here. So I gave you some background about the 401A2 process. So the EPA determined that it may affect. That's the first thing that happened. And then the band determined that it would affect and provided its analysis. All of those things are available on the Corps' website, so you can see those documents. And then during the hearing, the band not only demonstrated why the violations would occur and how they would occur and the resources that would be impacted, but they also had expert testimony that there was no condition that could be imposed that would prevent that violation, which is the trigger for the Corps not being able to issue the permit. So some of the impacts that are troubling is that it will cross nearly 200 water bodies and more than 100 acres of wetlands. We think that's an underestimation of the wetlands based upon the work that Glyphwick has done. The crossings, remember, are perpendicular, and so they will have more than just a de minimis effect on the waters in the surrounding area. They will have significant impacts to the surface waters. The blasting, which will fracture the bedrock, will also release metals. Enbridge says, oh, well, DNR doesn't think there's any metals in the area. Well, what DNR doesn't think is that there are mineable amounts, economically feasible mining amounts of metals. They have not rendered an opinion about whether there are any metals. So this is a giant unknown. Based upon the geology and the hydrology in the area, it is more than likely that it will release metals, which will then be transferred. The area where this where the project is going to be crossing is a groundwater exchange area that the USGS has established. That's almost 100% exchange. So blast things up from the bedrock, it swirls around in groundwater, it ends up on the reservation through subsurface means, and then it daylights on the reservation with these metals and these suspended solids and the turbidity. What Dr. Branfirerun testified was that there's lots of mercury in wetlands just from atmospheric deposition all over the world. But in wetlands, because of the anaerobic environment, they stay there. And when they are mobilized and released, if there is methyl mercury around or the conditions that generate methyl mercury, that's what fish uptake, and that's what impacts people. And what Dr. Branfirerun testified was, given this wetland-rich environment, given the fact that there's already impaired waterways on the reservation because of mercury, you are going to release mercury and methyl mercury into an already impaired environment where people are eating fish in larger quantities than the state of Wisconsin's risk-based standards, because Wisconsinites don't eat as much fish as Bad River members. So Dr. Branfirerun said there is absolutely no condition you can impose on that, because by its very nature, you are blowing up and impacting wetlands, and those wetlands are going to release mercury. It's just, that's what's going to happen. There's no doubt in his mind. And connected to Glyphwick's work about the connectivity and the connections directly from the impacted area to the reservation, that mercury and methyl mercury is going to be on the reservation, regardless of any conditions imposed by the state of Wisconsin. The horizontal directional drilling, or HDD, can release bentonite, clay, and fracking fluids. They inject it into the ground. They have blowouts. It's just like the sacrifice zone. That's what happens when you do HDD, and they just, collect it. We had some photographs during the hearing that had a huge spill of fracking fluid after a blowout. That's going to impact the wetlands. That's going to impact the surface waters. Enbridge says that its impacts are temporary. Temporary has a different definition under the Bad Rivers water quality standards, and it's not going to be temporary, even under those standards, even under the state of Wisconsin standards. It's going to be permanent for some of these wetlands, but certainly long lasting and take multiple seasons to recover. The 231 conditions already imposed on the project in Wisconsin's 401 certification won't prevent a violation of the band's water quality standards, because Wisconsin didn't consider them, because it's not part of the it's not what it does. The statute doesn't say, Wisconsin, you have to think about a downriver jurisdiction. So it's not that Wisconsin did anything wrong in not considering them. It's just that they won't and didn't consider them. And Wisconsin's water quality standards are not as protective as the band standards. So even if you perfectly apply the 231 conditions, that doesn't protect the band's water quality standards. This is the work that Glyphwick has done. It's their EPA's determination and the Corps' determination in issuing the preliminary determination is based on an incomplete understanding of the site hydrology. We have provided all of the new data and the mapping to the Corps and the EPA. And because the existing hydrographic data underestimate the connections, they also underestimate the magnitude of the transport of sediments and contaminants to the reservation. We heard testimony during the hearing from the band's technical staff that even when you have best management practices, BMPs, that are perfectly constructed and implemented, they are not designed, a construction, a silt fence isn't designed to prevent 100% of sediments from reaching water bodies. At best, they're 90 or 95, and that's if you're doing it perfectly. And that's in all of the technical data and the peer review studies. It's not perfect. It's not designed to be perfect. It's designed to be 90%. So that won't prevent contamination, sediments, impacts from construction project on the water bodies downriver. The invasive species, which the band refers to as non-local beings, the BMPs in the state of Wisconsin certification are, you should do this if it's practicable. If it's not practicable, you don't have to do it. So they don't have to wash off construction equipment if it's not practical, which absolutely means non-local beings will be transmitted into the water and will impact the reservation, and that's a violation of the band's water quality standards. The non-local beings taking over an area and invasive species outperforming another species, and also impacting soils and the ability of the soils to hold on to where they are. The construction means and methods, so blowing things up in those gentle explosions, which are not gentle at all, will cause short-term, long-term, and permanent impacts to the hydrology, the groundwater, the surface water, and the wetlands. That's just a fact. And that was introduced through expert testimony by the band. This is Dr. Branfirerun's conclusion. The impacts and changes will cause increases in mercury and methylmercury releases. It's the methylmercury that fish take up and then people eat. And it will cause those releases into an already mercury impaired environment on the reservation. And the conclusion is that there's no conditions that will prevent those violations. And because of that, then the Corps cannot issue the permit under 401A2 of the Clean Water Act. So those are the things you can pick and choose from. We'd be happy if you would support the band's efforts.
Connie, just having a glance at the talking points, it seems like it's more geared towards, because it's so specific towards people who really know what they're saying. So for example, scientists or people who are working in that field of water science. So I'm just curious, as a person who doesn't know anything about, I know something, but not a lot about science, how can I chime in and talk about these points? That would make sense. Do you want me to add stories, personal stories? Do you want me to, how can I bring these two together? Just curious.
So the bands, the residents of the reservation are providing their personal stories about how they use these waters. You can't fish on the Bad River Reservation or hunt on the reservation unless you're a band member. It's a violation of their natural resources code. So personal stories about impacts on reservation can't really come from people who live outside the reservation. But what you can say is, we trust the experts, and the experts are the band. They're the ones who have these water quality standards. They're the ones who enforce them, and their experts say it's going to violate them. Glyphwick says it's connected. We all can see the connections. If you've ever walked the lands outside the reservation in the Bad River watershed, we know that those things go to Lake Superior. And actually, Lake Superior is so powerful, it, as you were pointing out, Judy, or not Judy, Mary Kay's friend, it pushes it up almost 2 river miles up the Bad River. Waters from Lake Superior, it makes the river flow backwards. So all of that water movement, this wetland rich environment, it's going to impact everybody. It's going to impact this international jewel, and the Kakagon Slough and the wetlands that have been designated wetlands of international significance. Those are all going to be impacted by this project, and the band showed how. And so the Corps shouldn't issue the permit.
Great point. Thank you so much. And Britnie, let me circle back to your point. Like when you mentioned that we are looking for organizations or group to support, like, do you want people to share kind of same testament? We know that these are the experts, that's what they are advocating for, and we support them, or anything specific?
Mine was more of a general statement that if there are any groups or organizations who, oppose the reroute and support the Bad River Band, I would encourage folks to make that publicly known. I think if organizations and groups want to release statements outlining this, that would be a really great thing to have happen. There's a lot that's going to be happening in the next several months, August through October. And I think that if we can have groups and organizations that especially, are located in Wisconsin speak up and let their points of view be known on this, that would be a really great thing to have happen. And if anybody, is interested in that but maybe isn't really sure how to approach it, you can definitely reach out to me or look on the MEA website. There's a lot of really great information, about everything going on. And I do have, I don't want to interrupt a question, but I do have one other comment period that I can let everybody know about as well before we run out of time.
Are they working on the pipeline now?
Speak up a little more.
Are
Oh,
they
you're
working-
still,
Are they
Ah,
working on the pipeline now?
Is there any work going on the pipeline now?
There's not supposed to be, we'll say that. Yeah, there's a stay. The judge has ordered a stay in any construction.
Who is the judge?
The administrative law judge that was assigned to our case is Angela Chaput Foy.
Angela who?
Angela Chaput Foy.
How do you spell that?
I'll put it in the chat.
Thanks.
okay. When I know what was helpful for me, I did call the lead person for the Army group, and I pointed out I wanted to be, I had knew people who were very interested in what was going on, and that it was important for me as having been a lawyer to want to make sure that they're staying with what is in the subject that's usable, or and I asked him if he, because I think there was something in the article or something that all of that information that was given during the during that hearing would be available to us. I had no idea that I would be getting one link, but it had both of you speak, no, you speaking, Connie, twice, and the man you referred to that did all that chemical stuff. I could have fallen asleep during much of what was going on, but when you two spoke, and you, without any yelling and screaming, but with, the development of the tribe, the band creating their own requirements, were it was so I could imagine how that those kinds, just listening to those two speakers in particular, it give you the real undergoing that helps a lot with what makes sense to speak, to say, that would be appropriate and would be meaningful. I mean, it's always good to have the public, more of the public, to understand this. But anyway, that's I found that very helpful, and it's there for us for free. That they would send that one link, and you get all this, and you can just pick and choose from what you want. I just wanted to add that.
I have a question. Do we know how, B, do we know how soon this water, this rerouting could affect other areas like nearby cities, urban areas? Do we have any information regarding that?
So the only information I have on behalf of the band is on reservation. I don't know whether water quality impacts specifically are addressed in the contested case hearing.
I think, if that information could somehow, if we knew that information, it could help spark the urgency of why this is so important. I mean, this is important. I'm not saying it's not, but I think because possibly some people don't think it affects them or will affect them, they don't see the importance, even though I know that the fact that it's important affected anyone, it's important. But I just think that if we could show somehow how it could eventually affect others, it could also help people rally, come aboard.
So there are two expert consultants that the band hired who have provided expert reports, and I don't know, they've filed them in the contested case hearing. I don't know if those are publicly available documents. Britnie might be able to, no, it's not. Okay. So those expert reports talk about the impacts off reservation, specifically for the contested case hearing. Alice Johnston, who's a wetland hydrologist, and then a company called Limnotech talks about the subsurface impacts. And so they're the ones who talk about the water recharge area. And there's all sorts of unknowns about where that water flows other than on the reservation. It might be flowing off reservation to people's groundwater wells. I don't know the answer to that question, but that's an issue that will be raised during the contested case hearing. And those expert witnesses will be filing what's called pre-filed testimony. So you'll be able to read, once it's made public, you'll be able to read what their opinions are as though they were sitting there testifying. And then they just get cross-examined during the contested case hearing. So it may well be that this will come out during the contested case, Deborah.
Thank you so much. I think we are just hitting the time, 1 p.m. But John Peck has a question in the comments. It might be the last question. So do you want to give a shot?
Oh, as a matter of fact, my associate wrote a law review article about that.
Oh,
No, Bad River doesn't. So Rosalind DeLillo Knock, I can probably send you guys a link to her law review article about giving wild rice rights. The Bad River Band was offered $80 million to settle their case and let this happen, and they said no. And if you've watched the Bad River documentary, which I can see the movie poster behind Britnie, I can't tell you how surreal it was to see my client testifying on a giant screen in a movie theater. But the connection between the Bad River Band, which draws its name from the Bad River, obviously, is so significant that they are at present using the tools that exist to fight. They are not trying something that would be considered extraordinary or creative in the sense of Anglo-Saxon jurisprudence. They are using the tools that they have available to them now because they will prevail. I mean, presumably they would prevail if there's any justice, as they did with the trespass case.
thank you. Thank you so much. And really appreciate your time, Britnie and Connie. Really appreciate you. And so yeah, we will hopefully we'll try to spread the word out. It's really important. But really appreciate you both coming. And yeah, please go ahead, Britnie.
Yeah, I just want to mention very quickly that there is one public comment period on the state level for the Wisconsin DNR for an incidental take permit of the bronze holly fern. So I just put the link in the chat to get to that, to the comment site. But just really quickly from Glyphwick, they are expressing concern basically, the biggest thing with this is that that the DNR has only surveyed a small portion, a little over 7 miles of the over 41 mile reroute for rare species. So that is something that anybody can like comment, even if you don't know anything about the bronze holly fern, you can express your concern that they have only surveyed a small portion of the reroute for rare species. And that comment period is only open until June 8th, so there's a handful of days left in that.
Thank you. Thank you so much. Yeah.
While the other deadline that we have in our minds is the 13th, which is based on what most of today has been talking about, what's before it. Yeah. Bad River directly. Mhm.
Awesome. So yeah, thank you so much for being here, for sharing all this information with us. Really appreciate you all. And we meet every first Tuesday of the month, and we have that informal conversation. To feel free to join us, you all, next time. And thank you so much, Connie and Britnie. Have a wonderful rest of your day. Thank you.
Thank you.
Yeah,
too.
thanks.
Thank
Bye-bye.
you.
Really helpful. Thanks so
Thanks.
much.
Bye-bye.
Bye.
We'll be presenting much of this information